Today, we're diving into a pretty stunning court case out of Assam, India. It's all about a massive land deal that got a judge so worked up, he questioned if the whole thing was a joke. So, what could possibly make a high court judge say something like that? Let's get right into it. It really all kicks off with these explosive words right from the judge himself in open court. This quote from Justice Sanjay Kumar Medhi pretty much captures the shock that set this whole legal drama in motion. I mean, think about it. It's not every day you hear a judge ask if a government action is a joke. And this is the number that started it all, 3,000 bighas. Now, for those of us who don't use that measurement, a biga is a traditional unit of land in India. And 3,000 of them, that is a huge amount of land. We're talking about something like 1,600 acres, or maybe easier to picture, over 1,200 football fields. The sheer scale of this land grant to just one company is exactly what stopped the judge in his tracks. Okay, so let's go inside the Guwahati High Court and really unpack the judge's reaction, because it was, nothing short of total disbelief. So the case is pretty straightforward on the surface. You've got a company, Mahabal Cement, on one side, and the state of Assam on the other. And what's at stake? This huge piece of land in the Dima Hasar region that the company says it needs for its mining operations. In legal speak, words matter. A lot. The court didn't just call this deal big or large. In its official order, it used the term extraordinary. And for a court, that's a massive signal. It's basically like a big flashing red light, saying this deal is so unusual that it's immediately suspicious and needs a much, much closer look. And that brings us to the real heart of the disagreement here. Was this just some empty, barren land like the company was claiming? Well, the court had a very, very different take on it. This is where you really see the two sides clash. From Mahabal Cement, the story was simple. This is barren land, and hey, we need it for our business. But the court saw a much, much more complicated picture. They looked at the same land and saw an environmental hotspot and, just as importantly, a protected tribal district. So what did the court even mean by an environmental hotspot? Well, the Umringso area, it turns out, is not empty space at all. It's a region that's actually known for its natural hot springs. It's also a vital stopover point for migratory birds, and it's a habitat for local wildlife. The court's point was crystal clear. This is a living, breathing ecosystem. And on top of all the environmental stuff, there's this really critical legal layer here. The Dima Hasao district is what's called a sixth schedule district under the Indian Constitution. Now, that's not just some label. It's a powerful constitutional shield. It's specifically designed to protect the rights, the land, and the culture of the tribal communities who call that place home. So all of this really builds up to a fundamental conflict, one that's at the very core of this case. It's a classic battle, really. Private profit versus the public's interest. And the judge, he just spelled it out with absolute clarity. He looked at the company's lawyer and said, "Your need is not the issue. The public interest is the issue." I mean, that statement just cuts right to the heart of it all. It completely reframes the whole legal question away from what a corporation needs and towards the much broader responsibility of the state.
So what you have are two totally different sets of priorities. For Mahabal Cement, the interest is private, right? It needs land and resources to run its business, to make a profit. But the court's concern is the public interest. Its duty is to protect tribal rights and to preserve this incredibly sensitive environment. They're just on different planets.
Okay, so the judge is clearly shocked by the deal. The fundamental conflict is laid bare for everyone to see. The big question became, what was the court actually going to do about it? The court didn't just sit there and express its shock. It took immediate, decisive action. First, it completely shut down the company's barren land argument and hit pause on the whole thing. But then came the really crucial move. It demanded evidence. It ordered the government to produce every single official record explaining the policy that led to this massive land allotment in the first place. And that's the key thing to remember here. This case is far from over. Right now, everything is basically on hold while the court waits to review the government's files. The final outcome is going to depend entirely on what's in those records. Was there a fair, legal, and public-minded policy behind this?
Or was it, as the judge first suspected, something else entirely?
And this one courtroom drama in Assam leaves all of us with a really universal and incredibly tough question. It forces us to think about that delicate and often difficult balance between industrial development and preserving our natural and cultural heritage. It's a question with no easy answers, but one that we all have to face again and again.